All right. Well, thank you all for coming. I appreciate you being here on a Tuesday evening. My name is Henry Mantel. I'm a tenants' rights attorney and I'm running for LA City Council District 5. And I wanted to do a tenants' rights presentation to give people more information about their rights, make sure people are informed so that if they ever do run into any situations with their landlord or an eviction, God forbid, you have the information you need to handle it. So I'm just going to tell you a bit about me really quickly. I was raised in Los Angeles. I now live in Park La Brea, where I'm doing this presentation. I graduated from Harvard Westlake in 2010. I went to Brandeis University and graduated in 2014 and McGeorge School of Law in 2019. And now I've been an attorney since January 2020. If you want to look me up, my state bar number is right there. It's 330-156. And I've worked in tenants' rights for about four of the last 6 years, approximately. And I was a Mid-City West Neighborhood Council member from 2023 to 2025. So I've been involved in the community for several years now. All right. So this is just kind of what I'm going to be covering in the presentation. I'm going to start by going through the Los Angeles Rent Stabilization Ordinance and then the implied warranty of habitability, right of entry. I'll talk about discrimination and reasonable accommodations. And I'll talk briefly about evictions and government agencies, and then I'll provide some further resources. And then at the end, after I've gone through all the tenants' rights stuff, I'm going to talk briefly about the housing crisis, and then we'll leave time for questions. And I just want to say right off the bat, a lot of this stuff is going to be very truncated, very brief. Um, and nothing, this is a quick disclaimer, nothing in this presentation is intended to be legal advice. This presentation is for educational purposes only, and the information presented is subject to change. I actually started as an attorney during COVID, and I can't tell you when that was happening, people's rights were changing every 6 months. So, you know, all of this information could potentially change, but as far as I'm aware, it is up to date at the moment. Now, I am not agreeing to represent anybody or take anyone on as a client. I will answer questions, but be aware that nothing said or asked here is confidential or protected by attorney-client privilege. So just be aware of that. All right. So I'll start just by talking about the Los Angeles Rent Stabilization Ordinance. This is also known as LARSO, and LARSO applies to most multifamily housing built before 1978. And if you ever want to look up any of the statutes that I mentioned, I include the legal citation here. And LARSO starts at Los Angeles Municipal Code Section 151. And LARSO includes two things mainly. It includes rent control and includes just cause protections. And I'm going to go into each one of those things. And LARSO units are regulated by the Los Angeles Housing Department. So if you live in a LARSO covered unit and you have issues, you can complain to LAHD, and I'll get more into that a little later. All right. So rent control. LA has rent control, and under LARSO, the landlords can only raise the rent once a year, and they actually just tightened this up last year. Now a landlord can only raise the rent once a year from 1 to 4%, and it is determined by what is 90% of the change in the consumer price index. Starting February 2nd, 2026, it's been limited to a 3% increase. Um, and landlords, in order to raise the rent, landlords have to provide at least 30 days written notice of an increase. Now, a landlord can reset the rent if a tenant vacates. I've seen situations where landlords unfortunately have tried to force tenants out just so that they can reset the rent because the tenants were long term. Um, but typically, as long as a tenant remains in the property voluntarily, this rent control applies. But now a landlord can pass through SCEP fees, and SCEP is a program that LAHD has that requires inspections done every few years to basically ensure that the buildings are up to code. Now, if you do think at any point your rent was illegally increased, it happens. You can call LAHD and report the illegal increase. And again, if you need to look this up, this is LAMC section 151.06. All right. So now the just cause protections. So landlords, under Larso, landlords can only evict for a just cause. Now, what that means is they need a reason to evict. They can't evict for no reason at all. And these are typically broken into two different types. There are at-fault just causes and no-fault just causes. And an at-fault just cause for eviction is basically if the tenant did something that was wrong. They either defaulted on the rent or they breached the lease. If a tenant uses the property for an illegal purpose or a criminal activity, like if a tenant is caught selling drugs out of a property, then that would be considered a at fault just cause for an eviction. Or if they are damaging the property, causing waste, or if they are refusing the landlord reasonable access to the unit, all of these would be at fault just causes, and these would be valid reasons for an eviction. And then there are the no fault just causes, which is basically the landlord doesn't have a reason, or in that the tenant didn't do anything wrong, but the landlord wants them out anyway. And the landlord has, but it can't be for any reason. It has to be for some specific reasons. Like if the landlord or their family wants to move into the property themselves, they can evict. If they plan on demolishing, substantially renovating, or removing the unit from the market, that it also counts as a no fault just cause, or if they're ordered by the government to evict. That doesn't happen very frequently, but I have seen it happen. Typically, it's when a landlord has just let a place completely deteriorate, or if they if the unit is illegal and and the tenants aren't supposed to be there. And again, if you want to look up these just causes specifically, it's just LAMC section 151.09. You can always just Google it and it'll come up. Okay. Now, there are some other tenant protection laws that I really don't have the time to go into, but they may be relevant to you, especially if you don't live in Los Angeles. The first one being AB 1482, which is the Tenant Protection Act of 2019. And this is a California-wide law, and it's Civil Code Section 1946.2. And the Tenant Protection Act includes just cause protections and rent control. And it covers most multifamily units in California if it's not already covered by a local rent control or just cause ordinance like LARSO. But there are exceptions to that. So if you're not certain, you should look up the Tenant Protection Act directly and see if you fall into one. And then Los Angeles also has the Just Cause Ordinance, or JCO, and this is LAMC Section 167. Now, this is only just cause protections. This does not include rent control. This just requires landlords have a just cause for evictions, and it covers all residential tenancies in Los Angeles. So if you live in a property that is not covered by LARSO, the JCO still applies and the landlord still has to have a just cause to evict. And then the last one is the LA Tenant Anti-Harassment Ordinance, or Tahoe. This forbids landlords from harassing tenants. And what constitutes harassment is very broad. It can be anything from threatening violence to threatening to shut off utilities to illegally or failing to make repairs. It's a very broad law, and I really recommend looking it up if you're ever dealing with landlord conduct that is difficult or feels harassing. And now this is my favorite tenant right. This is the implied warranty of habitability. And this is why I had a job for the last year and a half. This implied warranty of habitability basically states that a landlord has to provide a unit that is fit for human habitation. And this is California Civil Code Section 1941. This applies to all residential tenancies in California, and it is implied in every lease. It cannot be waived in writing or by conduct. So even if a tenant even if a tenant reports a defective condition or something that's dealing with the health or affecting their health and safety, and the landlord doesn't fix it, even if they stay, the landlord still has to fix it. The landlord cannot waive this. It has to be done. And defective conditions can include infestations like cockroaches, bed bugs, rats come up, mold, water leaks, lack of hot water, defective wiring, plumbing, heating, locks, All of these can be considered defective conditions. Typically, anything that impacts tenant health and safety that the landlord doesn't fix could be a breach of the implied warranty. Now, if you have a defective condition, the first thing you want to do is you want to notify the landlord in writing, preferably. Text or email are okay, but you want to make sure that you do notify the landlord about it. And then you need to give the landlord a reasonable time to fix the problem. And reasonable is a very lawyerly word because it can be it can vary. What it means depends on the situation, but reasonable in this situation is typically considered 30 days. So a landlord usually has 30 days to fix a problem. Anything more than that is typically unreasonable. Now, if it's an emergency like a fire or a flood, then reasonable is typically considered to be immediately, not 20 days after the place is already burned down. So if there is an emergency, the landlord should get on it as soon as possible. And you also want to make sure you are documenting the defective conditions. So get photos or videos because you never know when those will come in handy. And now, if the landlord does not fix the problem, you tenants have some options. First, and this is what I always recommend tenants complain to a government agency about the situation. Which government agency kind of might depend on what it is you're dealing with, and I'll go through that later in the presentation. And then the other option is tenants are technically allowed to withhold rent if a landlord is not fixing things. And failure to fix something or breach of the implied warranty of habitability is considered a affirmative defense to an eviction for non-payment. Now, I will say I usually recommend holding off on doing this after you've complained to a government agency, until you've really given the landlord some time, because even though a tenant has the right to withhold rent, that the landlord can still go forward with an eviction. And you may have a defense to eviction, but with evictions, it can be hard to predict what's going to happen. And the eviction process is stressful and worrying no matter how strong your defenses are. So I typically recommend making sure if you are going to withhold rent, it's kind of a last resort. There is another option. It's called repair and deduct. A tenant can repair the problem themselves and deduct the cost of the repairs from their rent, but only if the cost of the repairs is less than 1 month's rent. And then finally, there is a constructive eviction. You can just move out if the landlord refuses to fix things. This is considered basically the landlord has not upheld their end of the agreement, and basically they're in breach of the lease, so a tenant has the right to just move out. And then finally, you could consider filing a lawsuit against the landlord, especially if you're dealing with serious health conditions due to these defective conditions. That's something to consider. And that was basically my job for a year and a half. I was a slum housing attorney suing landlords for defective conditions that the landlord never fixed. And, things get pretty bad, especially if you're dealing with things like mold or cockroaches or bed bugs. So you want to make sure that if you are doing that, you might want to consider a lawsuit. Uh, all right. So the right of entry. This actually causes a lot of I've found this causes a lot of problems between landlords and tenants, because landlords do have a right to enter a tenant's unit, but there are restrictions on that right. First being that if a landlord wants to enter a tenant's unit, then they have to provide reasonable written notice, and they have to have a valid reason, and they have to do it during normal business hours. Reasonable in this case is considered at least 24 hours. So a landlord has to provide at least 24 hours written notice before they can enter a tenant's unit. And it has to be for a good reason. And that usually means either they're making repairs or showing the unit to a potential tenant or buyer. Um, Now, in an emergency, no notice is required. So if the place is flooding or on fire, they don't have to give you 24 hours notice and wait for the place to burn down. They can just enter and deal with the problem. Now, a landlord cannot abuse their right of entry. So a landlord has to go through this process. They can't just barge in, but tenants can't completely deny access either. a tenant is legally required to allow a landlord the ability to make repairs, to fix things, to show the unit if necessary. So if you are dealing with a situation where where the landlord wants to get access to the unit, then you should work with them. If for whatever reason they say, they want to enter at a certain time and they give you notice and you're not comfortable with them entering at that time, you can ask them to just postpone it, try to work with them, but legally they only have to give you 24 hours written notice. And do not change the locks on your own. This is typically considered a breach of the lease, and it's also not legal. A landlord legally has to be able to have access to the unit at any point. If you do change the locks, the landlord, that is without giving the landlord a key, that is potentially grounds for an eviction. So just be aware of that. Okay. So discrimination and reasonable accommodations, this comes up pretty frequently. But discrimination under California law is illegal. And discrimination can cover also a wide variety of actions. So, in choosing to rent or providing services or selling, things like that, a landlord cannot discriminate based on all of these protected classes that are listed here. It is a lot of them, but I am going to read them out anyway because I think it's important that people understand that all of these are technically protected classes under California law. So those classes are race, color, ancestry, national origin, citizenship, immigration status, primary language, religion, disability, mental or physical, sex and gender, sexual orientation, gender identity, gender expression, genetic information, marital status, familial status, source of income, including Section 8, military or veteran status, and age. So a landlord cannot discriminate based off of any of these protected classes. Now, when it comes to disabilities, the landlord also has to provide reasonable accommodations to tenants with disabilities. But there are some caveats to that. So there has to be a nexus between the disability and the accommodation. So if a tenant is dealing with a physical disability, and then any accommodation they request of the landlord has to be directly related to that physical disability. It can't be something totally unrelated, and it cannot put an undue burden on the landlord. So it cannot cost the landlord a ton of money or a lot of time. It really has to be something that the landlord can reasonably accommodate, and it has to be related to the tenant's disability. Evictions. So evictions are can be very complicated. I was an eviction defense attorney for about 3 years. And I am going to be going through this very fast, but trust me, I could be doing a whole 45-minute presentation on each one of these bullet points. Um, so evictions are the legal term for them are unlawful detainers. There are also something called forcible detainers, but those are reserved typically for squatters. Unlawful detainers are for people who were lawful tenants at one point. And all evictions start with a notice to quit of some kind. And it can be a 30, or excuse me, a 3 day, a 30 day, a 60 day, or a 90 day notice to quit. Typically, 3 day notices to quit are almost always reserved for at fault evictions, so non-payment or breach of the lease. 30 and 60 day notices are reserved for no fault just causes or just cause evictions. And then 90 days is almost exclusively reserved for one particular type of no fault eviction, which is if the property has been foreclosed on. So you don't see that too often, but it does come up. And the notice to quit it has to follow the law to the letter. It has to be in writing, it has to be proper, and it has to be properly served. And it has to include all the necessary legal language, and proper service for a notice to quit means that the landlord either has to hand it personally to the tenant or they can post a copy somewhere on the tenant's door or around the tenant's door, somewhere conspicuous where it can be easily found, and then mail the tenant a copy as well. And that would be considered proper service of the notice. Now, once the notice to quit has been served, if the tenant does not move out or comply with the notice within the notice period, then the landlord can file the unlawful detainer complaint with the court and they are issued a summons. And the landlord then has to serve that summons and complaint on the tenant, either personally or again, they can post it. It's possible for them to post it on the door. And once a tenant is served with the notice, they have 10 business days to file an answer. And that's a specific court form. That's UD 105. If you have been served with a summons and complaint, you really want to make sure that you file an answer. Because if you don't file an answer within those 10 days, then the landlord can request a default judgment. The tenants get a judgment entered against them. And that means basically you don't get your day in court. The landlord can go forward with a lockout without ever actually going to court and you never getting a chance to defend yourself. So I tell tenant, like, even if you know you're moving out, you should just try to file an answer anyway, because you know you want to avoid a default if you can. Now, if you file an answer, then the landlord will request a trial date and the case will be set for trial, usually a few weeks out. You can also request a jury trial in your answer. But if the case goes to trial, then you'll have the opportunity to prevent your defenses, and the landlord will present their case. Now, if you win, you get to stay in the property and you get to keep paying rent. So during this process, the landlord is not supposed to be collecting rent, but the rent doesn't stop accruing. So even if you win, if you go to trial and win, you're still going to owe the landlord all of the rent that came due while the eviction was going on. Now, but if you lose, and losing is, I tell tenants, losing is the worst case scenario in an eviction, because then not only will you get locked out by the sheriffs, but you'll also get an eviction judgment on your record. You'll typically get a money judgment against you, and which can really harm your credit. And getting an eviction judgment can make it really hard to find a new place. Okay. And then finally, too, settlement is always an option. You can always negotiate. I've found that, and I will say a lot of evictions end in settlement one way or another. There are ways. Sometimes landlords will just accept some payment to drop the case. Sometimes they're willing to waive rent in order to give the tenant time to move out and seal the records so there's no eviction. But it really does depend. This is not something you can get any advice unless you're talking to a lawyer who actually knows your specific situation. So if you are interested in negotiating a settlement, you want to make sure you know what your defenses are, and you want to make sure you know what you need or what you're hoping to get out of the settlement. So affirmative defenses. Now, a landlord will have their case against you. If a case goes to trial, they'll have their case. And if you're a tenant, you will have affirmative defenses. When you file an answer to the unlawful detainer, you'll basically be checking the box next to any defenses that you think apply to your case. There are a lot of them, and which ones apply to your case depend entirely on your situation. But these ones I've listed here are kind of the most common ones I've seen. The first one being the waiver or estoppel defense. And waiver is basically if a landlord does something that waives their right to bring the eviction for whatever reason. So if a landlord accepts rent after a notice to quit, after serving a notice to quit and that expires, that's typically considered a waiver of their right to evict. Because if they serve you with a notice, then the assumption is that your tenancy is over. But if they accept rent afterwards, then they're basically implying that no, the tenancy is still on. And estoppel is a very similar argument, but different in a way that like only matters if you've gone to law school. But estoppel is basically if the landlord does something or implies something or acts in a way that leads the tenant to believe that the eviction is not going to happen or that they didn't have anything to worry about, then that's an estoppel affirmative defense. Retaliation is also a big one. If a landlord files an eviction against a tenant within 180 days of the tenant doing something like complaining about habitability or organizing a tenants union or doing something that the landlord doesn't like, then there's a implied presumption of retaliation. That is, it's presumed that the landlord is retaliating against the tenant. And this is just a presumption. It can be overcome. So if the landlord still actually has a valid reason to evict, then they can overcome this presumption. But it is an affirmative defense that can apply. The third one, most common one, is improper notice. This one happens. We used to use this one a lot because sometimes landlords and their attorneys would not serve the notice properly, or they wouldn't put the correct legal language in the notice. And if the notice itself is invalid, then basically the whole eviction is invalid. And then complied with the notice. So if a tenant, say, tried to pay the full amount of the rent within the 3 days of being served a 3 day notice to pay or quit, or they cured the breach of the lease from after within 3 days of being served with a notice to cure or quit, then that's an affirmative defense to being evicted. You complied, you did what you were supposed to do, and the landlord doesn't have a right to bring the eviction anymore. Fourth is the breach of implied warranty of habitability. Habitability, I mentioned this earlier, but a landlord cannot evict for non-payment if there are issues with the unit that the landlord has failed to fix. So if you are a tenant and you can prove that the landlord had notice of certain issues and was refusing to fix them, and then the landlord tried to evict for not paying your rent, you can use this as an affirmative defense. And the last two are discrimination and harassment. Now, these two can be harder to prove, um, and they typically only come up usually if there's something else involved. But if you can show that you are being discriminated against or the landlord is intentionally harassing you, those are affirmative defenses to eviction. So these are just a few general tenant tips I have. These are tips I give to basically every tenant I ever talk to. The first one being, and the first one is like a good general lawyer tip, but get it in writing. Document any issues with your unit, any communications with management or the landlord. Nothing counts unless it's in writing. If the landlord is insisting they communicate over the phone or in person, you can say, you know what, no, I'd rather communicate in writing or through email. That way there's a written record of it. Also, talk to your neighbors. If you're dealing with an issue, your neighbors probably are too. I've found that if a landlord is mistreating one tenant, they're probably mistreating others. And there is a lot of strength and unity when it comes to dealing with a landlord who is violating your rights. So definitely talk to your neighbors, get to know them. It's a good way to build community and to build uh, solidarity. And the third is you don't self-evict. You can always negotiate. I've talked with plenty of tenants who will like receive a notice to quit of some kind and then they'll just leave without any question, nothing, because they don't know what to expect or they don't know what their options are. Don't self-evict. You can always negotiate, and usually negotiating is a better option, even if you know there's no defenses, even if you know you need to leave for whatever reason, you can try to negotiate with the landlord for more time. And also, you want to know your rights. I have unfortunately run into the situation where landlords really count on tenants not knowing what their rights are. And the more you know about your rights, the better, and the harder you are to coerce or influence in any way. So we want to make sure you know what your rights are. That's what this presentation is about, making sure people understand, what protections they have in what situations. And the last tip I have seems pretty standard, but you should read your lease. If Because the thing is the lease is supposed to cover just about every situation, every circumstance. It's the contract of your tenancy. And if the law doesn't apply, or if you don't know what the law says about a situation, see what your lease says about it. Now, it may include the leases sometimes include terms that are void, invalid because of public policy. But typically, like boilerplate leases that these big property management, big landlords use, they're usually fine. They've usually been reviewed by lawyers and they're usually okay. But if you ever have any questions about your tenancy or what the terms are, you should go back to your lease and see what it says. So government agencies are very, very useful when it comes to enforcing tenants' rights. Some more than others, I will say. The Los Angeles Housing Department, as I mentioned earlier, covers all rent stabilized units in Los Angeles, in the city of Los Angeles specifically. It is a city agency, and they will take complaints about illegal rent increases, reduction in services is a big one, habitability concerns, illegal evictions, harassment. They will take complaints about all of them. Now, I will say they can be kind of toothless. They won't necessarily do much more than send a strongly worded letter, but they are worth complaining to anyway because, as I said, it's good to create a written record of these things. And if there's a written record of a complaint to a government agency about an issue, it is good evidence that you can use at any point if you end up in court. The second agency is the Los Angeles County Department of Public Health, or LADPH, and they are a little bit tougher on these issues, and they usually handle issues that affect public health, like mold or infestations. Um, and I recommend calling them if you're dealing with situations like that. Now, now, the issue I have with them is that you have to follow up with them. So if you complain to them, they'll send the landlord a courtesy notice, basically saying they've received a complaint about an issue and the landlord has to solve it within 30 days. If the problem still doesn't get solved within 30 days, you have to follow up with LADPH, give them a call and tell them the problem is still there. And then LADPH may send an inspector out. So just be aware of that. And then the last one is the California Civil Rights Department, and they handle claims of discrimination. And they are typically the most serious government agency. Um, and, oh, oh, sorry, hold on. Oh, okay. Um, they are a very serious government agency, and so if you are dealing, they take claims of discrimination very seriously. So if you're ever concerned you're dealing with discrimination from a landlord or property management, you want to make sure you give them a call. Okay. So these are some further resources if you are dealing with issues. As I said, I'm not taking any clients at the moment, so I can't really help much further than providing information and education. I really recommend checking out Stay Housed LA if you are having any issues. They do a lot. Not They can help depending on where you live. They may be able to help you provide legal services if you are getting evicted, but they also have a lot of workshops, a lot like this one, where they will have attorneys who will give presentations and tenant advocates who know what they're talking about, who can answer any questions you have. So I really recommend checking them out if you're dealing with any further issues. And then there are legal aid firms across LA County, and there are a bunch of them. Neighborhood Legal Services, or NLSLA, is the one I used to work at as a stay house attorney doing eviction defense. But then there's also BetSedec, Inner City Law Center, Legal Aid Foundation, Eviction Defense Network, and BASTA. These are all good groups, and they all kind of have different criteria for who they can help. So I would recommend if you are dealing with a situation, you can call around and see who may be able to help. And then there are also the LA County self-help centers. Basically, every courthouse has a self-help center in it, and almost all of those self-help centers can help with some basic explaining or helping fill out forms. They do a lot of help with like filling out answers for unlawful detainers. It's something that they're a really good resource to use if you have any questions like that. And then finally, the LA County Bar Association. Now, this is more for if you need a private attorney, if you're looking for someone who can help you sue your landlord, or you have, negotiations or something else like that. Um, the LA County Bar Association has an online attorney referral service called Smart Law that can be very useful if you're looking for a private attorney in LA County. All right. All right, so that was the tenants' rights portion. I'm just going to do my quick spiel about the housing crisis, because, working as a tenants' rights attorney, what I've found is that sometimes all the tenant protections in the world don't really help because there is a deeper underlying problem with with the housing market in Los Angeles. And we all feel it, we all know it. Rents are skyrocketing, housing costs are going up. It's caused a lot of problems. It's led to a lot of landlord harassment and abuse. And I kind of want to just discuss really quickly why that is, because it's I think a lot almost worse than a lot of people realize. So this is basically the zoning, or excuse me, the housing crisis in two graphs. The first is a map of zoning capacity versus actual population of LA. And so what this is basically showing the black line is zoning capacity and the red line is actual population. And what happened is in 1960, LA had a zoning capacity of about 10 million homes, which means we could have legally built 10 million homes. And even though we only had a population of about 2.5 million people, but then by the 1990s, the city had instituted some very strict zoning rules that dropped that zoning capacity to 4 million. And by 1990, we were basically at capacity in terms of population and zoning. And you know, from 1994 to 2025, like the population of LA increased by 8.5%, but the population of this country increased by 29%. So we really just did not build enough housing, and that's clear in the second graph here. This shows housing construction over time by decade in Los Angeles. And you can see every decade since the 1960s, LA has built less housing than the preceding decade. Like 85% of the housing in LA was built before 1990. And so this is actually a real shortage that is way more severe than I think a lot of people realize, and this is causing a lot of problems. And and this map is basically shows you why we have such a problem. This is a map of single family zoning in Los Angeles. The red on this map is single family zoning. So in all of the red area of that map of Los Angeles, it is illegal, outright illegal to build more housing, and it covers more than 70% of the city. It was implemented in the 60s and 70s, and this map has barely changed at all in the last 50 years. So we've basically spent the last 50 years in a city where we were intentionally limiting the amount of housing that was built, and it's causing a lot of problems. Now, there are some other issues as well, like construction costs. I've talked with people who build housing, and it's even the permitting process alone can take years and cost millions of dollars. And then there's also just a very strong uh, anti-development sentiment that goes along in that has been prevalent in Los Angeles for a long time. You may have heard of NIMBYism or not in my backyard, and it's pushed by like homeowners associations, landlords who, do not want to see more housing get built. They don't want to see housing costs go down. So they really fight as hard as they can to make sure that no housing gets built, and they want to make sure this map stays exactly the way it is. So this is, I don't know if anybody's ever heard of the housing theory of anything, everything. It's a term housing advocates use to basically refer to the fact that the housing crisis really does relate back to just about every other issue we're dealing with. And the most obvious one being the cost of housing. Like the median price of a home in 1990 in Los Angeles was $212,000. Now in 2020, it's 800. And I'm sure that's only gone up in the last 6 years. And like from 2010 to 2019, the average rent increased by 65%. So this housing crisis is really driving the cost of housing up. This is also driving persistent homelessness because it turns out the cost of housing is what is most strongly correlated to rising homelessness. It's also damaging our environment because of single family zoning. We've been required to spread out, created a lot of sprawl, which has basically made us dependent on cars and fossil fuels. And then education is getting affected because LAUSD enrollment has dropped in by half in the last 20 years because the cost of housing has gone up. People can't afford to have kids, so there are fewer kids, there's less funding for education. And right now, around 17,000 of those students in LAUSD are homeless. And then there's also the social justice element of this because single family zoning was actually invented as a way of keeping people of color and immigrants out of white neighborhoods in Berkeley, California. So it is a remnant of segregation. And unfortunately, people of color and members of the LGBTQ community are disproportionately homeless. So this does affect them disproportionately than any other group. There's also business issues because higher rents means less disposable income for other goods and services and higher costs. There's also a tax problem uh, because of Prop 13, we can't raise property taxes. But if we were to allow for more housing, we would be able to expand the tax base without raising taxes. It would get more people here. We could raise more revenue and by just having more people pay into the system. And then there's also an issue with the federal government because California has become so unaffordable that we're actually set to lose representation in the House and the Electoral College after 2030. So in order to reverse this trend, we just need to be building a lot more housing here in LA. And this is basically why I'm running. I want to do something about the housing crisis and make sure tenants have more options, make sure housing can be more affordable, make sure we're driving rents down instead of just watching them go up every year. And first thing I want to see done is eliminating single family zoning, just making it legal to build across LA. And SB 79 is a law that the state passed recently that would have legalized housing near transit stations, but unfortunately, the city council in LA just keeps dragging its feet on implementing it, keeps stopping more housing from getting built. Also, permitting reform, just making it easier and faster to build. And then also stronger tenant protections. Like I mentioned, LAHD is kind of toothless. That really bugs me. I think the housing department should be doing a lot more to enforce tenant protections, make sure landlords who are taking advantage of the housing crisis are held accountable. And thank you. That's it. Oh, didn't take as long as I thought. Um, so thank you all for coming. I really appreciate it. I am happy to stick around for questions. If you'd like to make a donation to the campaign, that would be a big help. The QR code right in the middle there will take you directly to my Act Blue page. If you can, it would be a huge help just so we can get the word out and hopefully try to solve this housing crisis, try to get a lot more housing built and make LA more affordable and walkable for everyone. And also, you are welcome to follow along on social media, check out the website. And yeah, I hope this was useful.